Hello and welcome to Courts Today by Live Law. Let us get to today's top legal updates. A plea has been filed in the Madras High Court seeking guidelines against uniform worn by delivery partners of quick commerce platforms being misused by criminals. A plea has been filed in Orissa High Court to declare Netaji Subhash Chandra Bose as national son and to declassify secret files on him. The Supreme Court is set to pass orders on SCBA application to clarify direction on recording lawyers' appearances. The Supreme Court has held that testimony of witness should not be discarded merely because of relation with the victim. The Madras High Court has held that under the POSH Act, any inappropriate or unwelcome behavior affecting women is sexual harassment regardless of intent. The Madhya Pradesh High Court has directed Indore Excise Commissioner to decide representation in a PIL filed on inaction against illicit liquor trade in 4 weeks. BJP legislator CT Ravi, booked for abusing female Congress leader, has got interim protection from Karnataka High Court till 30th January. I am your host Urvashi with your daily roundup of legal updates from across the country. For detailed reading, you can always visit www.livelaw.in. Please make sure to watch this video till the end and do not forget to like, share and subscribe to our channel because your support means the world to us. The Madras High Court has today issued notice to the Director General of Police on a plea seeking formation of guidelines for monitoring and regulating delivery partners of online delivery service providers such as Swiggy, Zomato, etc. Justice P. Velmurugan issued notice to the DGP on a petition filed by Nithyanantham and adjourned the case by 4 weeks. Nithyanantham has filed a plea in the High Court raising concerns about lack of proper identification and regulation for delivery partners working with platforms like Swiggy, Zomato, Dunzo and Zepto, etc. He pointed out that although these companies expect their delivery partners to wear uniforms, many of them either fail to do so or do not carry identity cards displaying their name and details. In some cases, delivery partners arrive wearing helmets, making it difficult to identify them. He expressed concern over the rising incidence of crimes being committed by individuals posing as delivery partners. He argued that people wearing delivery uniforms often go unsuspected as others assume they are waiting to make a delivery. This loophole, he said, could be exploited for unlawful activities. Nithyanantham had also made a representation to the Director General of Police requesting the formulation of clear guidelines to regulate delivery partners and prevent misuse of uniforms. However, no action had been taken, which he termed as arbitrary and unjust. He now approached the High Court seeking appropriate directions to ensure that delivery partners adhere to uniform and identification norms, thereby reducing the risk of crimes and improving public safety. In the next update, a writ petition has been filed in the Orissa High Court seeking to recognize Netaji Subhash Chandra Bose as the national son of India and to declassify secret files related to him, including Intelligence Bureau documents. The petition also requests the court to declare Netaji's birthday, that is 23rd January, as a national day and his birthplace museum in Cuttack as a national museum. Furthermore, the petitioner has asked for public release of Transfer of Power Agreement 1947 and the Mukherjee Commission's inquiry report regarding Netaji's mysterious disappearance in 1945. Let me tell you, the Mukherjee Commission, led by former Bombay High Court Chief Justice Manoj Kumar Mukherjee, was constituted in 1999 to investigate Netaji's disappearance. During the hearing, it was submitted on behalf of the petitioner that a prior request to the Prime Minister had been forwarded to the Ministry of Home Affairs, but no action was taken. The division bench of Acting Chief Justice Arindam Sinha and Justice M. Shekhar Sahu denied the petitioner's submission of a memo about the ministry's inaction, stating that it was a separate issue. The court granted time for the union government and state government to file affidavits indicating their positions on the matter. The hearing has been now scheduled for 12th February. The Supreme Court has today said that it will pass orders clarifying its directions on recording of appearances of advocates in cases. A bench comprising Justices Bela M. Trivedi and Satish Chandra Sharma was hearing a miscellaneous application jointly filed by the Supreme Court Bar Association and Supreme Court Advocates on Record Association seeking clarification of the direction passed in September last year that only the appearances of those lawyers who argue or appear in a case would be recorded. If you recall, this direction was passed in the case of Bhagwan Das versus State of UP, in which the court issued a CBI inquiry against the lawyers who filed a fake SLP by forging the signatures of a party in the Wakalatnama. The SCBA and the SCAORA took objection to the direction regarding marking of appearances, saying that it would result in unfairness towards those lawyers who assisted in the drafting of the petition and research work. Both associations have filed a separate writ petition also seeking a declaration that all advocates present and appearing in a case are entitled to get their appearances recorded in the orders as per the Supreme Court rules. Today, it was the miscellaneous application filed in the Bhagwan Das case seeking clarifications regarding the directions listed before the bench. Senior advocate Kapil Sibal, who is also the president of SCBA, informed the bench that the associations will not take forward the previous writ petition, and that the associations would jointly submit a proposal to regulate the issue of whose name should be added in the order along with the arguing counsels. Justice Trivedi then remarked that many lawyers are present with the arguing counsel, but nobody seems ready to argue. She further said that in court orders, names of lawyers go into 10 pages and the order goes into a few pages. She said that court had no issue with adding the appearance of lawyers who assist on the matter effectively. The bench said that it will pass orders clarifying the same. In another update, the Supreme Court has observed that being a victim's close relative does not automatically make a witness interested or biased. A bench of Justices Vikram Nath and Prasanna B. Virale was deciding on a criminal appeal preferred by the accused against his murder conviction. As per the allegations, the accused had animosity with the deceased due to a property dispute. This led to an attack on the deceased and he succumbed to his injuries. Initially, the trial court acquitted all the accused of the charges as it found the witnesses' testimonies unreliable. It also pointed out the discrepancies between the medical evidence and the eyewitnesses. Though according to the eyewitnesses, the victim was struck multiple times on the head, however, the same was not mentioned in the medical report. But in spite of these findings, this verdict was reversed by the High Court. The High Court observed that the trial court had overly focused on minor inconsistencies and had overlooked the overall credibility. So now the accused approached the top court against the order of the High Court. The top court agreed with the High Court's findings. It accepted the High Court's reasoning for not discarding testimonies given by eyewitnesses merely because they were closely related. Distinguishing between an interested witness and a relative witness, the court said the term interested refers to witnesses who have a personal stake in the outcome, such as a desire for revenge or to falsely implicate the accused due to enmity or personal gain. A related witness, on the other hand, is someone who may be naturally present at the scene of the crime, and their testimony should not be dismissed simply because of their relationship to the victim. Regarding the facts of the case, the court said that the eyewitnesses' testimonies were consistent with regard to the victim being attacked by the accused persons. Their presence on the spot was also well established. Regarding inconsistency in statements and the medical report, the court said that if the eyewitness's version inspires confidence, the same is sufficient for the conviction of the accused. Further, medical evidence was used to corroborate eyewitnesses' evidence. The court opined that minor discrepancies could not render the testimonies unreliable. It also pointed out that as per the medical evidence, there was a fatal injury to the head. The same was also sufficient to cause death. In view of this, the Supreme Court upheld the High Court's judgment and concluded that the evidence produced clearly established the accused's guilt beyond a reasonable doubt. Moving further, the Madras High Court has emphasized that under Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act, the act of sexual harassment itself is given significance and not the intention behind the same. The observations were made in a plea filed by HCL Technologies against an order of the Principal Labour Court that overturned the recommendations of the company's Internal Complaints Committee against an assistant general manager accused of sexual harassment. The AGM, while working as a service delivery manager, had allegedly hovered too close to a woman employee while she was seated. Another woman claimed he repeatedly asked her about her physical measurements, making her uncomfortable. A third employee alleged that he kept questioning her about her menstrual cycles. After an internal inquiry, the Internal Complaints Committee or the ICC found the AGM's behavior inappropriate and classified it as sexual harassment. It recommended making him an individual contributor without any supervisory role and denying him pay raises or benefits for 2 years. The AGM challenged these recommendations, claiming a violation of the natural justice. The principal Labour Court ruled in his favour, reversed the ICC's findings. Thus, the HCL approached the High Court against the same. It argued that the Labour Court did not consider the evidence and that the AGM's challenge came only after his termination, though the recommendations were issued earlier. It asserted that the ICC followed due process and complied with the principles of natural justice, which vary depending on the facts of each case. The AGM, on the other hand, contended that he was not given critical materials like witness statements or cross-examination answers. Regarding the allegations, he claimed that his actions were part of his job as a supervisor and that the measurements were sought because the company was distributing coats to female employees. But the High Court has now quashed the order of the Labour Court and allowed the plea. Justice R.N. Manjula observed that in cases under the Act, what has to be looked at is not what the accused thought was decent, but how such a person made a person of another gender feel about his actions. Thus, the court held that any gesture putting the opposite sex in an embarrassing or uneasy position was an unwelcome gesture within the meaning of the Act. In another update, a PIL petition was filed in the Madhya Pradesh High Court against liquor merchants alleging that they were carrying on illicit trade of liquor against the established procedure of law in Jahabua, Alirajpur and Dhar districts. Further, it is alleged that small and young children have been involved in such businesses, thus infringing the provisions of Prohibition of Child Labour Act. Moreover, it says that people who try to report such acts are subjected to physical assaults and life threats. The petitioner had also made multiple applications to the Excise Commissioner. Still, no action had been taken against the liquor merchants till date. It was also alleged that the liquor merchants were taking advantage of people belonging to backward and vulnerable groups in the three regions, enticing the women, children, and young generation of these groups by giving them money. The petitioner prayed before the court to direct the authorities to take action and properly register any offence made out against them. A division bench of Chief Justice Suresh Kumar Kaith and Justice Vivek Rusia heard the matter and directed the Excise Commissioner Indore to take an action on the representation within 4 weeks. And lastly, the Karnataka High Court in an interim order today asked the state not to precipitate any action against BJP legislator CT Ravi till 30th January. Ravi has been booked for allegedly using derogatory words against Congress legislator Lakshmi Hebalkar against the state council at Belagavi. The incident reportedly took place after the House was adjourned due to protests from the opposition. Ravi contended in the court that Speaker of the Legislative Council investigated the matter and closed the issue because the inquiry found no inappropriate conduct. A complaint was filed in December alleging that Ravi's words insulted the modesty of a woman, which falls under Section 79 of Bharatiya Nagrik Suraksha Sanhita. The complaint led to an investigation by the CID, which was challenged by Ravi, claiming parliamentary immunity. His counsel, Senior Advocate C.V. Nagesh, argued that statements made within the legislature, even when not in session, are protected under parliamentary privilege. The state argued that parliamentary privilege does not extend to criminal acts such as insulting the modesty of a woman. It claimed that the incident occurred after the House was adjourned and the Speaker lacked jurisdiction. After hearing the arguments, the High Court adjourned the matter to 30th January. The court will primarily decide on the jurisdiction and scope of parliamentary privilege in such cases. Stay tuned.